Yes. That was your lunch.
Well, yeah. Well, over the short adjournment I have, a short additional bundle has been put together. Lord the Master of the Rolls, I know that your Lordship doesn't like hard copies. We will email it to you, but I wondered if you'd be prepared to look at the hard copy.
Can't you email it? Can't your junior email it to my clerk? Yeah, sure you can. I'll have it quicker than you.
All right. Well, I'll come back to it once that's been done. Let me just continue with where I got to. So, my sixth heading was the judge's approach in theory. We have, I think, covered that. It was by reference to paragraphs 220 and 221, cross-referring to 33 to 35, and I've dealt with my submissions in relation to that already. I was then, my seventh heading and final on this ground was the judge's approach in practice. Again, I've made submissions to, and we've covered it, I think, at some length, the structure and the approach that the judge took in going through the issues. My learned friends have sought to demonstrate that because of the judge's premise, apparent premise, that His Honour Judge Russon was right, that somehow Mr. Justice Leech abrogated his own decision-making. And they've sought to do that by reference to two particular examples, and I'd like to deal with those if I may. The first example concerned Mr. Laycock's reluctance for supporting the company's board in June 2018. For your note, that's paragraph 31 of the appellant skeleton. That was in the context of issue 6. So if I could ask you to look in the core bundle at page 237, and it is paragraph 342 in the judgment. And in that, you'll see immediately prior to the paragraph, the heading is, was Mr. Laycock induced to step down as a director of the company in July 18 in order to permit Mr. Tinkler's removal using Article 89.
So where are you reading?
Just immediately before paragraph 342.
342 in the judgment?
In the judgment, yes.
Yep.
So that is the issue, and the findings of Mr. Justice Leech on the issue start at paragraph 350. So this is his normal structure. What's the judge find? What's the new evidence? What are my findings on that? So 350, having considered the evidence of all four directors, I find that Mr. Brady asked Mr. Laycock to step down as a director of the company in July 18 because he was concerned that Mr. Laycock was not prepared to support the remainder of the board at the AGM. He accepted this much in answer to a question from Mr. Wardell, but I also find that Mr. Laycock's resignation from the board was not part of a preconceived plan to buy off Mr. Laycock and exercise Article 89(5). Mr. Brady did not accept this, and I accept his evidence on this point. He then explains his reasons, not only that he's accepted Mr. Brady's evidence. In part, he refers to Mr. Wood's evidence in 351. He says that what's called the Laycock note provides the best evidence of Mr. Brady's motives for asking Mr. Laycock.
Was that an old document or a new document?
That was a new document. Yeah, it was a new document. He indicated that it provided clear evidence that Mr. Brady had a genuine concern for Mr. Laycock's health, his ability to cope and his ability to discharge his functions as a CFO. it refers obliquely to 89.5, but as Mr. Brady said, this is not a foregone conclusion, and the board might never need to exercise this power. Further, the note provides no evidence for Mr. Tinkler's case, and so forth. Then at 354, finally, in reaching these conclusions, I've taken into account the fact that Mr. Laycock's reluctance to support the board in June 18 was induced by the threatening behaviour of Mr. Warwell, who sent Mr. Laycock a text message on the 29th of May stating that SGL's insurance did not cover him for defending the defamation claim. And he refers to paragraph 267 in the Russon judgment, which sets out the text message which he's referring to. The judge described this message as intimidating and rejected Mr. Warwell's evidence that he was not acting at Mr. Tinkler's direction. I note here that Mr. Warwell did not give evidence before Mr. Justice Leech. He did before His Honour Judge Russon. He then says Mr. Tinkler could not and did not challenge these findings before me. Doesn't stop there. He carries on. Mr. Brady put his meeting with Laycock and the change to his employment terms in this context. He also gave evidence that as well as texting him, Mr. Warwell telephoned Mr. Laycock and threatened him. And then he quotes Mr. Brady's evidence on this. So in the fourth line of the quotation, just as a little context for Laycock, so when we issued the RNS on the 29th, Laycock was called by Warwell. What we understand was quite a threatening conversation in terms of he would not be covered by the D&O, the insurance, he would end up with no house. So there's kind of an implicit threat to Laycock, who already is not the most robust character, right? So he was already felt threatened literally within hours of the release of the RNS. Last two lines, Laycock got a call very early, like 3 or 4 in the morning, if I remember rightly, with this threatening structure of, look, the insurance won't cover you, you're going to lose your house, we're going to take everything away if you sign it. And then the last line, so that's the context of Laycock and what you're putting to me. So, learned friends seem to suggest that Mr. Justice Leech stopped on this issue because of what His Honour Judge Russon had found. And in my submission, that is transparently not the case. One small aspect of his reasoning is that that His Honour Judge Russon had the body of a text message, which Mr. Justice Leech could read in the judgment, that His Honour Judge Russon had made findings about what Mr. Warwell's intention had been in sending it, that had not been challenged in the fraud claim, and moreover, that the evidence that His Honour Judge Russon had was reflected in evidence that Mr. Justice Leech had given to him orally by Mr. Brady about Mr. Warwell threatening Mr. Laycock. So there simply, in our submission, there simply is nothing to this point. There was a careful analysis of all of the materials for the judge to reach a conclusion in relation to it. The second of two examples is at paragraphs 45 to 47 of my learned friend's skeleton at page 17. And that concludes with the suggestion that Mr. Justice Leech used as a factual starting and, they say, and very often ending point, the Russon judgment. And the example they give in relation to that is, and I quote, Mr. Ferguson and his Wilton Park emails. And what my learned friends do not do is refer to the judge's, that is Mr. Justice Leech's, actual findings. And again, these appear in the judgment a little bit further on at page 255, paragraph 372. So, you see immediately before the paragraph, the issue is identified, issue 8. So failure to capture all of his emails and a deliberate deletion, as was asserted, of Wilson Park emails. In the context of this, he goes to the judge's findings. Mr. Tinkler has not identified any individual emails which Mr. Ferguson failed to disclose. This was an inferential case. Essentially, and then at the end of the paragraph at the top of the next page, none of the judge's findings are relevant to either of these sub-issues, which is not a propitious start for a submission that the judge starts and ends with the findings of His Honour Judge Russell. What the judge goes on to do in his standard approach in this case, at 373 and onwards, he sets out in detail all of the evidence that there was in relation to this. At page 259, paragraph 381, under the heading dishonesty, he sets out Mr. Ferguson's evidence in relation to these matters. And then at paragraph 385, deals with the two sub-issues. Firstly, was there deliberate non-disclosure? So line 3, I reject that allegation. I accept Mr. Ferguson's evidence that he followed Rosenblatt's instructions and that he believed that he'd done what he'd supposed to do, and so forth. And then at the top of page 262 in the same paragraph, I reject Mr. Tinkler's first allegation for the following reasons. And then goes on to give 4 separate reasons justifying his conclusion. And that includes, for example, subpara 4, Mr. Wardell did not point to any obvious points, which could only be explained by Mr. Ferguson's failure to disclose emails from his Wilson Park account. I'll return to this. Next page, para 386, he makes findings in relation to the deletion of emails. I am not satisfied that the experts' report and explanations provide cogent evidence that Mr. Ferguson deleted any emails from his Wilson Park account for the following reasons. And there then follows a detailed analysis of the evidence that he, Mr. Justice Leech, had heard on this issue. And so, for example, at subparagraph 6, Mr. Wardell, line 4, Mr. Wardell did not draw my attention to a single email sent to or by any of those individuals to or from Mr. Ferguson's Wilson Park account, and which Mr. Ferguson or Mr. McGaw had failed to disclose. This strongly supports Mr. Ferguson's evidence that he did not delete any emails from that account and that he disclosed all relevant emails. And then at 8, in summary, therefore, I cannot draw the inference that he deleted emails predating the 3rd of May 2018. He gives a more likely explanation. 387 have taken into account my overall assessment of Mr. Ferguson's evidence. I found him to be honest and credible. In particular, I'm satisfied that he would have understood that the emails on his private email account were likely to be more important, and that the company was likely to disclose the emails on his Wilson Park account from other sources. I'm satisfied, therefore, he didn't have a motive, far less a strong motive, to prevent disclosure of his emails predating the 3rd of May 2018. I therefore find that Mr. Ferguson did not consciously and deliberately choose not to disclose emails from his Wilson Park email account predating the 3rd of May, or consciously and deliberately delete any of those emails. Having reviewed those findings of Justice Leech, it is extremely difficult to understand the proposition that he took the findings of His Honour Judge Russell as a starting point, let alone an end point. My learned friends have said that Mr. Ferguson's protestations that he hadn't deleted the emails necessarily could only take the learned judge so far. But that may be the case. If someone says, well, I didn't do it, where does that get you? But the analysis that Mr. Justice Leech undertakes of the evidence that he heard on this issue shows that he didn't stop with a protestation. he analysed it closely, as a trial judge ought to, weighing the probabilities on the issue before him. Now, my learned friends have suggested that there might have been other things that ought to have been put in the pot. For example, the contention that Mr. Ferguson had lied at a much earlier point when he had said that Mr. Tinkler had expressed a wish during a conversation before a committee meeting on the 24th of January to step down from the board. But that is a classic example. It's in the passage that I took you to in His Honour Judge Russon's findings under the initial heading of context, where he's analysing the evidence by reference to everything that he's heard over the long period of time from September onwards, and having heard both Mr. Tinkler and Mr. Ferguson as to what had happened at the meeting immediately before the committee meeting on that date. It depended upon an understanding of that history, and that was evidence which His Honour Judge Russon had, and Mr. Justice Leech did not have. So again, it is a criticism without any merit. Now, and the alternative way of looking at this is that my learned friend implies that the approach that we propound would have a profound consequence on these types of claims because it cuts off relevant material. And we reject that. My learned friend scrabbled around for a few examples, and only a few, where he suggests that the judge was unduly fettered by accepting our submissions on the approach to be taken. Those examples are, with respect, anything but convincing. One example that my learned friend gave was in relation to what was called the Travers Smith memo. For your note, that's described by the judge in the judgment at paragraph 120 on page 133. But in my submission, this really illustrates the problem, not with our approach, but with the appellant's approach. It was a document that had been properly disclosed in the original proceedings. It was in the trial bundle. But it had not been deployed on behalf of Mr. Tinkler at the trial before His Honour Judge Russell. At that point, Mr. Tinkler and his lawyers did not see it, I infer, as any sense material to his claim that there was a concerted effort to remove him. But now my learned friend here says to this court that it was clearly central to the question whether there was a plan to oust Mr. Tinkler. He does not say that because a new document shines light on it and gives it some new meaning which was hitherto obscure. This is simply a different advocate taking a different view and seeking to rerun the issues. Now, I'm hoping you may have...
I've got it, Ian.
You have. I'm extremely grateful to my learned student. Over the short adjournment, we handed up a file which has 11 kbw at the very bottom. And these are some documents that have been referred to in the course of this morning. At the very beginning is the list of issues.
Which is interesting.
Which, as you see, is intended to be a short summary of the key issues arising in the case, not a substitute for the statement.
Was it agreed?
It was agreed.
Mm-hmm.
Was it not? It was agreed, yeah.
Because a lot of the questions are in fact reflected in Mr. Wardell's statement of the factual evidential matters for decision.
A number of them are, that's
Yes.
right, because a number of particularly the later issues where he's talking about was there a failure to...
Well, was false evidence.
Exactly right. I'm grateful. Exactly mirror that.
Yeah.
But in relation to documents, for example, did Esken fail to disclose any of the documents pleaded, including specified ones, that were under its control? Did Brady deliberately delete messages? Did Ferguson deliberately delete emails in respect of any document that was disclosable in the 28 proceedings and was not disclosed? That is, from within the parameters in paragraph 1. Was that deliberate or inadvertent? Were any deliberately non-disclosed documents material, and if so, how? And so forth. The second document, which is immediately behind that, not in a different tab, I referred to my learned friend's written opening. He may take you to different passages, but you'll see on the second page there's a contents page, introduction, Mr. Tinkler's concerns, the law, the factual background, and then at E, the conscious and deliberate dishonesty constituting Esken's fraud. And if one goes to page 74 of the document, para 196, Mr. Tinkler relies on the following conduct as constituting conscious and deliberate dishonesty, and then there's a summary, and then at 1, deliberately failing to disclose documents. Summary at page 75 of Esken's duty of disclosure, and then 76, the New Year's resolution note, 78, the 19th of January text message exchange, 81, the 29th of January note, 82, the Stobart email, and so on and so on. Tracking, in my submission, the pleading. Now, perhaps something of greater note for your lordships are the authorities which we've produced. Can I ask you to look at them in chronological order?
So which documents are we looking at? Which page in this bundle?
So there's Flower and Lloyd as the first case.
Page?
168.
Commendably short.
That was something to my relief as I was eating my lunch. But, the judgment, there are 3. The first, in the report, page 299, the Master of the Rolls, a lot of what he is saying is, this is 1877, so it is trying to understand.
None the worse for that.
No, but the context, that gives you the context, the description of the fusion of
just happened.
And what does that mean? So what he says is, if there were no other remedy, I should be disposed to think the relief now asked ought to be granted, for I should be slow to believe there was no means whatever of rectifying such a miscarriage if it took place, but I'm satisfied there is another remedy. In the first place, it must be remembered that the old practice remains when not interfered with by the new rules, and secondly, that all the jurisdiction of the old Court of Chancery is transferred to the High Court of Justice. Now, had the Court of Chancery any jurisdiction to give relief in such a case? It plainly had. If Lord Reesdale said, if a decree has been obtained by fraud, it may be impeached by original bill without the leave of the court. In most cases, you must obtain leave. The fraud used in obtaining the decree being the principal point in issue and necessary to be established by proof before the propriety of the decree can be investigated. Where a decree has been so obtained, the court will
that's really important, isn't it? Because that's the essence of it. You've got to show the fraud used in obtaining the decree
Yes.
In other words, the act of giving evidence falsely or concealing documents or suborning witnesses or whatever.
Indeed.
Yeah.
So, so there's no doubt that under the old practice, you could have brought an original bill to impeach a decree for fraud and could have got relief in fraud in obtaining, if fraud in obtaining the decree was proved.
There's no magic in the Chancery Bill. I mean, this is all to do with the origins of law and equity, which I think, for this purpose, are probably steeped in the mists of time.
Yes, yes, indeed. Can we look at what Lord Justice James said?
Yeah, yeah.
This is at the foot of page 301 of the report. I agree with what has been said by the Master of the Rolls, that in the case of a decree, or judgment as we call it now, being obtained by fraud, there always was power, and there still is power in the courts of law in this country to give adequate relief. But that must be done by a proceeding putting in issue that fraud, and that fraud only. And then, a few lines further on, that would be tried like anything else by evidence properly taken, directed to that issue, and wholly free from and unembarrassed by any of the matters originally tried.
It's good the examples he gives. You bribed the witnesses, you bribed my solicitor, you bribed my counsel. I mean, that it's not an example we'd give these days. But it's,
in the commercial court, we use kidnapping. Kidnapping, yeah.
But I mean, it's interesting because he says expressly, you obtain the judgment by fraud and I will have a rehearing. But you cannot say, sorry, you obtain the judgment by fraud and I'll have a rehearing of the whole case until that fraud is established.
Exactly. Yeah. Exactly.
I mean, this is all very orthodox stuff. Is there anything in Lord Justice Bagolet?
The second case in time is at page 152, that is tab 2. Boom.
152. Hip Boom Home.
So, if I can ask you to look at page 891 of the report. This is Lord Buckmaster. And just over halfway down, an appeal against such a judgment would indeed have been difficult to support, and the application for a new trial was not based upon any complaint in connection with the original hearing, but upon the ground that further matter had been disclosed, which showed that the defendant's case was so tainted with fraud and dishonesty that in the interest of justice the appellants were entitled to have the matter heard. The material upon which this charge of fraud was framed in part consists of the affidavits of certain witnesses, one of whom had given evidence at the earlier trial, but chiefly of certain documents, of which possession was secured by the issue of a search warrant. At page 893, the first complete paragraph, a third of the way down, their lordships regard with great disfavour the method of obtaining the evidence which these documents disclose, but they are unable to find that even if the purpose was dishonest, and there's not sufficient material before them to decide that issue one way or the other, the dishonesty produced any result that had the least effect upon the mind of the learned judge who heard the case. And then at 894, for those who have a hole punch, at the first hole punch, it's about a third of the way down, it's at the end of a line, in all. So in all applications for a new trial, the fundamental ground must be that there has been a miscarriage of justice. If no charge of fraud or surprise has been brought, it is not sufficient to show that there was further evidence that could have been adduced to support the claim of the losing parties. The applicant must go further and show that the evidence was of such a character that it would, so far as can be foreseen, have formed a determining factor in the result. Such considerations do not apply to questions of surprise and still less to questions of fraud. A judgment that is tainted in effect by fraudulent conduct is tainted throughout, and the whole must fail. But in the present case, their lordships are unable to say that such a case has been established.
I mean, it's not correct, is it, to say that the fundamental ground is the miscarriage of justice?
No, and this judgment is oft cited for the next bit, which is that you've got to plead your fraud and prove it. But the bit that's before that is not consistent with subsequent authority.
I mean, is this an extempore judgment of the Privy Council?
I don't think
No.
No.
It's a month later.
So the last, it's the very end. The fraud must be both alleged and proven. The best.
It's an appeal from Shanghai.
Yes.
His Britannic Majesty's
That's
Supreme
right.
Court for China sitting at Shanghai.
Does that give us an enhanced status or a lesser status?
Matter of interest.
So that I'm in my submission, that doesn't really take the case much further, other than, as I say,
It's Privy Council.
fraud must be pleaded and so forth. It's the council. Then 159 in the soft copy, tab 3, UNESCO. Again, Lord Buckmaster, but some 12 years later, at page 300 in the report, at the second hole punch, so 2/3 of the way down, line begins merit examination.
So 29.
300.
Yeah.
So the line begins merit examination 2/3 of the way down. I continue. It is the charge of fraud that is the sole reason supporting the judgment now under appeal. Viewed simply as a matter of procedure, the course taken was irregular. It's long been the settled practice of the court that the proper method of impeaching a completed judgment on the ground of fraud is by action in which, as in any other action based on fraud, particulars of the fraud must be exactly given and the allegation established by the strict proof such a charge requires. What is, I suggest, of interest is the approach that was taken by the House of Lords in that case. And one can see that the review that is undertaken, so if you look at page 302, having summarised the trial judge, just over 1/3 of the way down, it is the truth of that story that was investigated by Mr. Justice Morton, and it need not be again examined. In connection with the transaction, however, 4 important documents were produced at the trial referred to by the Master of the Rolls as 9, 10, 11 and 12. And the analysis that follows is of those documents. So number 9 is a document incorrectly printed, number 10 purports to be, number 11, number 12, top of page 303. Taking these documents in order, there is no evidence impugning 9 and 10. There's nothing whatever to suggest that these gentlemen are not what they purport to be, and nothing to show the receipts are not in proper order. A similar conclusion in relation to document 11. And then at 304, this leaves only document 12. And this is the one on which the whole judgment depends, for it is the fraud believed to have been connected with this that has tainted the whole proceedings. So in my submission, to the extent that this takes us anywhere, it is that the review by the House of Lords was looking at the newly produced documents document by document in order to identify what fraud had been perpetrated on the court.
Very colourful cases, aren't
They are.
and he also had a bit of a view about the Chinese case. He said that was the jurisdiction in special cases to satisfy the judgment for fraud on a motion for a new trial. Hip Fung Yong was such a case, but should be remembered that this case had come up to the Privy Council on this procedure, and the board would naturally be unwilling to defeat a case at this last stage on such ground. And he was explaining it away even then.
Indeed. The last case, additional case, is the Tuv Yahoo case.
Where's that?
Which is page 115, tab 1. And that is the case that emerges, if you remember, from endnote 99 in the Highland case. And the Lord was right, it was misspelt in the endnote. It is cited as proposition for materiality, operative cause of the decision, and it makes that point. I'm afraid pages aren't numbered, but luckily early on in the judgment. There's the first page of the judgment of Mr. Justice Law's introductory, goes over to the second page, and then at the third page you'll see there's 4 numbered propositions.
This is an extempore judgment, of course.
And the 4th proposition...
No, this is a reserve judgment. I think it's a reserve judgment. In fact, he apologised. He says that at the end of the second paragraph.
It is of enormous, substantial length. It couldn't possibly be.
Well, except that he delivered it orally because it's approved, transferred.
Yeah, I think he's at the end of the second paragraph. It says this reserve judgment would have been delivered at the end of last Trinity term, but I was given to understand the plaintiff was travelling abroad and it was consequently postponed.
What it's cited for in Highland is the proposition that one finds as proposition 4 on the 3rd page of the judgment, and then numbered and indented to flag them. Those were the submissions as to the correct propositions, and the 4th was the false evidence must be shown to have been an operative cause. And at the top of the next page, Mr. Justice Law says this: the 4 propositions seem to me plainly well established in the present state of the law, but I should say a word about proposition 4 relating to causation. By operative cause, I mean that the fraud must have procured the result. Now, so that's what it's cited for in Highland. The rest of it's a slightly peculiar judgment in as much as it is a claim in this jurisdiction in relation to a judgment obtained in a different jurisdiction. And so it seems to be simply a claim of fraud in some rather a claim that the original judgment had been obtained by fraud, rather than a claim challenging a court of coordinate jurisdiction within the same jurisdiction. So the principles that the judge is applying are not completely consonant. Effectively, it seems to appear as if there was something of a rehearing. But I think that's because it is a cross-jurisdictional case. So so it's only relied upon in Highland for that 4th proposition. I was going, if I may, to move on to ground 2. And unsurprisingly, much of what I'm going to say has been heralded in a review of the authorities. But in my submission, Mr. Justice Leech did not apply a restrictive approach to materiality. My learned friend's criticism is that the judge followed the test as stated in Highland rather than that in Hamilton. The judge concluded that there was no distinction between the tests, but if there was, then Highland was the correct one. And my learned friends now say that he was wrong in both conclusions. That is to say that he was wrong as to the first conclusion, that there was no distinction between the tests. Could I ask you to look in the respondent's supplemental bundle, which is the fairly slim white one that we went through first thing this morning. And if we look in tab 6 at page 74, you'll see that these are my learned friends' submissions in opening dealing with the law. And paragraph 14 deals with attribution, and then 15 turns to the question of materiality.
Sorry, I'm not on the right page. Which page do I need to be on?
So it starts at 74.
Thank you.
So these are the claimants, appellants, opening submissions on the law. And at paragraph 15 on page 76, they deal with the Hamilton-Highland distinction. At paragraph 16, they say that Hamilton is to be preferred and give their reasons. And then at page 79, at paragraph 17, they said this: even if, contrary to Mr. Tinkler's submission, the test in Highland does represent the law so far as the requirement of materiality is concerned, it is only because, in fact, the test in Highland is not in practice materially more stringent than that in Hamilton. While the test in Highland was applied by Mr. Stephen Gashevik, Queen's Counsel, sitting as a deputy in Takar when the matter was remitted by the Supreme Court, he evidently did not regard the two tests as materially different. See paragraphs 56 to 60 of that judgment, where he held that Hamilton was shorthand for Highland. So what my learned friends were saying to the trial judge was, we prefer Hamilton over Highland, but if we're wrong, they're not materially different. See the Gastovics judgment. And that is exactly what the judge held. So
that's a good forensic point, but surely they are different, aren't they? One, in essence, was the judgment obtained by fraud, and the other is, might the judgment have been obtained by fraud, i.e. was there a serious risk that the fraud gave rise?
Well, shall we look at the Highland test? At page 341 of the authorities bundle. So material means that the fresh evidence that is adduced is such that it demonstrates that the previous relevant evidence, etc., was an operative cause of the court's decision. Put another way, it must be shown that the fresh evidence would have entirely changed the way in which the first court approached and came to its decision. Thus, the relevant conscious and deliberate dishonesty must be causative of the impugned judgment being obtained in the terms it was. So that that is the Highland approach. Was it an operative cause of the court's decision to give judgment in the way that it did? I say that that's clear and that's appropriate law. I mean, for the purposes of this appeal, I say it doesn't matter whether it's Highland or Hamilton. There are two primary reasons for that. Firstly, the judge says, I'm applying each. So let's, and I can take you through, there are endless references to that. At each point, he says, whichever test I'm applying, this is the outcome. The second is, and Lord Justice Popplewell has, I think, identified this point, the judge actually goes further. When he makes any of these findings, he doesn't just say, I'm not satisfied that the test, whichever it is met. He makes specific findings as to where he says what difference, if any, he says that this would have made. An example, I can take you through each one and give you the reference to each one. But if we look at the judgment, page 210, paragraph 2778, 277 subpara 8. This is on issue 1. He says, I have been through this detailed exercise to demonstrate that in my judgment, the new evidence would have had a marginal effect on the judge's findings at best.
I'm so sorry, I haven't got the...
So it's page 210.
Thank you.
What paragraph?
287.
287, I'm sorry.
Oh, you said 278.
I'm sorry, that's entirely my fault.
287.
287.
287 sub 8.
Sub 8. So page 210. In my judgment, new evidence would have had a marginal effect at best. So you don't. What he's saying is you don't get anywhere near either Hamilton or Highland. You're just not even remotely in the territory of either. I can give you the references if it helps, but for example, on issue 2, he says exactly the same. Marginal effect. Issue 3 would not have been material. Issue 4 is the same as issue 2. Issue 5 would not have been material. Issue 7 would have come as no surprise to the judge. I find it impossible to see how such a conclusion would have affected the findings, and so on. So at each point, we're not looking at which test is relevant, because it makes absolutely no difference to the outcome.
There was one, wasn't it?
There are two.
Two.
The first is issue 8. That is dealt with at page, hoping I haven't mistyped again, it's at page 265.
Yes, 389.
Para 389. So this is in relation to the deletion of the Wilson Park emails. Now, I've just taken you through the findings of fact in relation to that. And he says, this is page 265, para 389, fourth line, I should record that if I had found that Mr. Ferguson had deliberately deleted or failed to disclose emails from his Wilson Park email account, I would have been prepared to draw the inference that the emails which he had prevented from disclosure were material to the judge's findings from that conduct alone. That one can entirely understand. If there's a complete absence of emails from a certain source, and the judge finds that that has been deliberately done, so that there was not only an absence of these emails, but that this had been dishonestly achieved and deliberately achieved, then can't possibly know what was in them, so can only conclude that they were material. The second example is at page 299,
paragraph?
459, I'm so sorry. So this is in relation to the loan agreement. So, in relation to every other issue, the difference between Hamilton and Highland, completely irrelevant. In relation to those two issues, also irrelevant, but for the other reason. So it simply isn't something that this court, in my submission, needs to go into.
And does that mean, as I think I put to Mr. Wardle, that issue ground 1 is entirely irrelevant, save in respect of those two issues, issues 8 and 16?
Yes. Now, what Learned Friend says on that is essentially that the methodology was so wrong on ground 1 that that alone is enough for this case to go back to a judge to be retried. The real difficulty with that is looking at what this judge says about materiality. So what my Learned Friend's submissions get you to in relation to ground 1 is a finding, or a potential finding, that there had been a fraud. But that doesn't to any degree undermine the reasoning of the judge on issues of materiality, which he's expressly considering in the alternative. He gives reasons why, even if this had been shown, except in these two instances, even if this had been shown, then it wasn't material to judgment, to any degree. And that is, in our submission, unimpeachable, and means that Learned Friend has to succeed on ground 1, and ground 2, the problem with ground 2 being that the judge makes findings which mean that his submissions are completely irrelevant.
Well, you say he can't succeed.
Well, of course I do, yes. I do.
But I mean,
no, absolutely.
Not in a trivial way.
No, I do say
it. Way, but you say he can't succeed because the judge, he's hoisted with the judge's specific findings on materiality.
Exactly right.
Which he has not got permission to appeal. And even if he wins on the point that it is the Hamilton test, that doesn't matter because the judge has given findings on the Hamilton test.
Well, has given findings on the Hamilton test and also given very specific findings of his level of gradation of materiality, which don't get anywhere near Hamilton.
Yeah, and issue 6 he didn't get permission on.
Yeah.
Yeah.
So the last ground is ground 3, and I'm not sure quite where we stand with this, but the ground appears to be that in following Cochrane, this led Mr. Justice Leech to misapply Highland. The short answer to this in our submission is that Mr. Justice Leech did not misapply Highland. The approach he took was to apply the final limb of Highland to assess the fresh evidence by reference to its impact on the evidence supporting the original decision, that is, the decision reached by His Honour Judge Russon, and not by reference to its impact on what decision might be made if the case were to be retried on honest evidence. That's the approach the judge took, and that is undoubtedly the correct approach. the new evidence must be something which would have influenced the original trial judge. It is not open house on the second trial judge, the fraud trial judge, to redecide these issues. In order to apply the Highland approach, it's necessary to assess how the original trial judge reached his conclusions. Might the new evidence, if known, have impacted upon those conclusions? All that Cochrane does is to point to the evidence, to identify the evidence that is material for those purposes. It is the evidence that would have been given absent dishonesty. It's not the simple fact that there was dishonesty. And that is entirely separate from the Highland Lim 3 question. So there are two stages. What is the new material that the fraud trial judge should be considering? Secondly, how is the materiality of that new material to be assessed? On the first stage, Cochrane offers an answer, the evidence that would have been given had there been honesty. On the second question, materiality, Highland provides the answer. You don't retry, but you consider the impact on the original judge. In any event, in the event, Mr. Justice Leech doesn't blindly accept the full potential ramifications of Cochrane. He decided that
you say Cochrane is wrong?
I don't have to go there. The judge approaches the case in a modified Cochrane way, and I don't have an issue with the way in which he addresses it. I don't particularly have.
I mean, prima facie, you'd. I mean, if it's being cited, you say it's right, do you?
Well, I do say it's right, but let's see what the trial judge, or Mr. Justice Leech, said about this. So this is page 100 of the core bundle, paragraph 26 of the judgment. So first of all, he cites the relevant passage from Cochrane, Mr. Justice Tugendhat. In particular, the question is not how would the judge's conclusions have been affected had he known that the witness was not a straightforward and frank witness. That's because we're running on an assumption that the trial would have been run on honest evidence. Would there have been a different outcome? Might there have been a different outcome had the case been run on honest evidence? So what the judge says is, I accept that submission as a matter of general principle, but in my judgment, there will be cases in which the new evidence is so fundamental to the credibility of the witness that it will be material, even though it is not directly relevant to the substantive issues. For example, if a solicitor gives evidence that she's a solicitor and holds a valid practicing certificate, but conceals from the court that she has been struck off for mortgage fraud, I would consider evidence of the striking off to be material. Likewise, where two witnesses conspire together to mislead the court, I would consider evidence of the conspiracy to be material. The second example is perhaps a more readily understandable one in the context of a real trial. If in the fraud it comes out that two witnesses have been conspiring together, what Mr. Justice Leech is saying is, well, the fact of that conspiracy might be relevant. Now, in my submission on a purist approach, that isn't the right approach, but it's of no impact. The real question is the judge applies in material places the Cochrane approach, and I don't understand how it is said that that undermines, and this is the ground of appeal, don't understand how it's said that that led him to misapply Highland.
But I mean, it's in the first example is it's very hard to see how it would not be material, because a solicitor pretending to be a solicitor who is giving any kind of evidence and is not denying they've been struck off throws really everything into doubt. The position of the solicitor in the case. And the second example, I mean, it's very hard to imagine a conspiracy to mislead the court on a subject that was irrelevant to the judgment. There wouldn't be a great deal of point in such a conspiracy. It's possible, but I mean, a bit.
Well, as I say, whatever the niceties
can stand on the point of
exactly, whatever the niceties of it.
Yeah, I mean, this is a case about. I mean, I personally think it's being a bit. The important thing here is that this is a fraud case where you have to prove fraud.
Yeah.
And when you prove the fraud, it all falls into place. And if you haven't proved the fraud, it doesn't.
Yeah. And what
fraud
I'm not
has to be an operator fraud.
What I'm still unclear of is how learned friends say that identifying what the material evidence, what the material approach is, which is to look at what is the evidence that ought to have been given to the trial judge, is that material, how that somehow shows that the approach that the judge took in applying Highland was somehow wrong. I simply don't follow the example. I mean, the instance of the judge applying his approach is at page 299, paragraph 459 of the judgment. So this is back to the loan agreement. And this is where he says, in the normal case, I accept Mr. Leeper's submission that the court should approach Lim 2 on the basis adopted in Cochrane. But I take the view that a conspiracy between a party and a witness to commit perjury is so fundamental to the integrity of the court process that it would have entirely affected the way in which the judge approached his decision. So that's how he applies it. I think my learned friend has given, and he gave them to you by paragraph reference only. But my learned friend suggests that the following are examples of misapplying Highland. So first of all, paragraph 287 of the judgment on page 208.
Sorry, 287.
287. So paragraph 286, I approached Lim 2 by considering whether the new evidence would have led the judge to change his other findings, and if so, what effect this would have had on the overall outcome. I also approached this question on the basis that the new evidence, which I may take into account, consists not only of the undisclosed documents themselves, but also the evidence which the witnesses gave about them, which I've set out or summarised in section B above, which is the section which sort of precedes the dishonesty section. Approaching Lim 2 in this way, the claim does not satisfy me either. The new evidence would have entirely either on the Highland or the Hamilton test. I say it for the following reasons. What my learned friend says, in subparagraphs 1, 2 and 3, the judge gets it wrong. So one is this: the judge was not asked to decide whether Mr. Brady had devised a plan to remove or neutralise Mr. Tinkler by early January. It wasn't necessary for him to decide that issue. It's difficult, therefore, to see how the new evidence would have had a decisive impact on the findings which he did make. Mr. Brady's private notes were just that, private aid memoirs, which had no bearing on any of the issues. I accept that Mr. Brady's exchanges with Soames would have revealed that he was firmly in the company's camp by the end of January. The judge was well aware of this fact and said as much. Mr. Brady never accepted or acted upon the proposals in the Stobart buyout email and attachment, and those documents would have provided no evidence of wrongdoing by Stobart Group. Now, just looking at that, I simply don't understand why it is said that that reveals a completely erroneous approach. The judge is saying, the judge already, His Honour Judge Russon already knew that Mr. Soames was firmly in the company's camp by the end of January. He was well aware of it. He said it in his judgment. So how is it material that it would have revealed this? Mr. Brady didn't act on the additional documents, and they provided no evidence of wrongdoing. So again, how would they have affected the judge's thinking? Whatever one thinks about the conclusion, the criticism is of the analysis, that somehow the analysis is wrong, and that is something which I don't understand. I'm not going to go through all of the examples, but they are of a similar nature. So I'll just take one other example just to show the reasoning. It's at page 286, paragraph 432. So this is on issue 13. Did Soames knowingly give certain false evidence at the trial? And the judge says this: the fact that Mr. Soames did have an ongoing relationship with Stobart, did provide some services to the company, wouldn't have had any effect on the judge's findings. It's not relevant to consider how the findings would have been affected if he'd known that Soames was not a straightforward or frank witness. But even if it had been, it would not have been material to any of the findings which the judge made, apart from trial issue 1, and on that issue, SGL loss. So there are a number of examples. So what in our submission, none of these examples show any error of approach. Mr. Justice Leech was considering his Honour Judge Russon's assessment of the evidence he had in order to consider whether the new evidence might have impacted upon them. It's obviously a fine line in undertaking that process, but the fraud trial judge, Mr. Justice Leech, did it unimpeachably. My Lords, unless there are any other matters I can assist with.
Thank you very much, Mr. Lever. Mr. Wardell.
Give me a minute, please, just to organise myself. My learned friend made it clear in the course of his submissions earlier today that he wasn't taking a pleading point, but he did suggest that the way I closed the case was very different from the way I opened it. And that just isn't correct. And I just want to take you to draw your attention to how we put it in our written opening. And then I was going to take you to a couple of passages from my oral opening. You should have received, my Lord Justice Ross, a copy of the transcript for day 1 by email this afternoon. I don't know whether it's reached you.
Yeah.
But insofar as the way our written opening, I don't think I need to take you to any particular passage, but from paragraph on page 27, we have a heading of Mr. Brady's plan to remove Mr. Tinkler.
Sorry, where's the written opening?
You'll find that in the first tab of the KBW file handed up this afternoon.
Thank you.
Hey.
If you turn in that piece to page 27, you'll see that we have the heading plan to remove Mr. Tinkler, and then we run the chronology right the way through up to page 67, in each case referring to both the old and the new document. And it was a point I debated with Mr. Justice Leech during my oral opening. I think possibly because my learned friend had said something about it in his written opening. When we start in tab 1 of the Wilberforce bundle, My Lord Justice Force, I think you need to start at page 12 of the e-bundle if you have it, or the soft copy if you have it. And at paragraph, page 44, looking at the internal numbers on the manuscript, I say at lines 3 through to 11. Yes, there is.
I missed the page.
I'm sorry, it's page 44. Yes, there is. The real point about that, the thrust of our argument, is that once you see the full run of the document,
So 44 of what?
of the manuscript, which it ought to be your page 12, it's
Ah,
day 1 transcript.
okay, got it.
Thank you. The real point about that, the thrust of our argument, is that once you see the full run of the documents, you understand with much greater clarity what the true position was, you know. There was enough material there for Mr. Taylor, who was cross-examining on behalf of Mr. Tinkler, to be trying to get to certain points, but he couldn't deliver the blow because he didn't have all the material that he should have done. Then if we go on to page 76, page 20 of the e-bundle, and at page 76, line 8, I say this. Before I pass the baton to Mr. Leeper, I want to say a little bit more about the relevance and significance of Mr. Tinkler's case that was a plan to oust him. As the court will have appreciated, much of the way we put our written case is directed towards the existence of that plan, and the reason it matters is as follows. First of all, it was denied by Mr. Brady and Mr. Folkes in the witness evidence. Their case was their actions were a response to Mr. Tinkler's wrongdoing, and the tipping point hadn't been reached the 9th or 10th of June. If there was in fact a plan to remove Mr. Tinkler, which had been formed long before, it renders their evidence on that point false. Secondly, in this regard, you'd have seen the importance attached by Judge Rushton to the events in early 2008. And then we can pick it up at page 78, where Mr. Justice Leech says this: it may be that Mr. Leeper will disagree with this formulation. The way I look at it in a very binary way at the moment, although what you said this morning means I don't have to decide any of these issues, that if he'd persuaded them that he didn't intend to resign, that they had a preconceived plan to get rid of them, which is why I say, did he jump or was he pushed? Exactly. That would have rendered the dismissal unlawful so far as the directors were concerned. Yes, and it certainly would have informed the judge's thinking on all the other factors, like the publication of the RNS, the setting up of the subcommittee, was it independent, and so on and so forth. If you have a pre-formed plan to get rid of Mr. Tinkler, then you set up a subcommittee comprising Mr. Brady, Mr. Coombs and Mr. Wood. Mr. Coombs and Mr. Wood both said they'll resign if Mr. Folkes doesn't get re-elected. If you know that's been done in the context of a preconceived plan to get rid of him, then it takes a very different shape. Then on to the bottom of 79, you'll see line 21. Justice Leech says this is the point Mr. Leeper makes, which is if you just look at the documents in isolation, then hard to say, but it's inviting you to undertake the wrong task. That's not for you. The question is, you know what the question is, and then we go over the page to page 81. Perhaps I can actually start at 82, where the learned judge says at line 7, I just have to be considered that you were deprived of fair trial, or the judgment was obtained by fraud. It's a serious allegation we make. I make no bones about it. I was taking you to the judgment. If we can go on to page 119, you see at paragraph 575, the judge starts a very long analysis of the context which informs the rest of his decision making. This passage starts at 119, you can see goes right through to 125, paragraph 614. And he addresses the other issues against the findings he's made about the context. So it's a fundamental part of his reasoning, and my learned friend cannot escape from that just by saying, look at Duranta, there's no appeal on that. It's not the point of this. The point of this appeal is whether or not the judgment has been obtained by fraud. If it has, did the fraud relate to material matters? And that question is, would it have impacted on the judge's evaluation? You'd be given an impossible task to decide, having done that, and now it's going to go on. I'm now got to decide whether it would have made going through each of the individual issues. That's not what you have to do. It would be an impossible task to ask a judge to undertake. And back to the plan, we said inference is how the accounts of Mr. Brady and Mr. Folkes variously gave the discussions surrounding Mr. Tinkler's future in early 2018 should be viewed. If both men were really angling for Mr. Tinkler to leave, any account that Mr. Tinkler was adamant he was going to resign needs to be viewed with the greatest scepticism, there being the distinct possibility that the account was a product either of wishful thinking or the desire to try and push Mr. Tinkler to a desired outcome or both. And the plan is relevant to what Mr. Tinkler could reasonably be expected to do. If he was indeed the victim of a plan to oust him, formed for any potential wrongdoing, it was an entirely different complexion on the steps he took, for which the majority made complaint. Rather than being offensive measures, they became defensive, which goes back to your point. But if the judge was satisfied there was this plan, the 29th of May RNS was part of it, the setting up the subcommittee was part of it. In those circumstances, Mr. Tinkler's response by way of his letter takes on an entirely different complexion, yes. So that really is my next point. If there is a plan, it influences the propriety of each and every step taken by the majority towards removing Mr. Tinkler, as it takes the decisions the majority purported to take in reliance on his wrongdoing. And as you'll hear in due course, they wanted him out in January, February, certainly still wanted him out in May, long before Mr. Tinkler took any of those steps. And I think there's a draft RNS produced, I think it's probably stifled in mid-May, basically announcing Mr. Tinkler's termination for any of the events that the other side...
So why are we going through this at such length? I mean,
But to make it clear that I was... One is to highlight what I was saying about the plan, but more importantly, in answer to my learned friend's point, that I didn't open the case in the way I closed it. Because I made it absolutely clear in this passage.
Well, I think the only thing he said was you didn't have a list of factual findings you wanted in opening. But you did obviously say the plan was crucial.
Yes. I said...
But we don't need to read the whole thing.
No, but he was taking the point against me that I hadn't opened the case in the way that I closed it.
Yeah.
By saying you should look at all the documents, but I had. So
right.
That's the first point. And as you'll have seen, no pleading point was taken by my learned friend in closing, and the learned judge thought it perfectly appropriate to consider the factual issues that we'd outlined. Now, my Lord Justice Voss has made the point on a number of occasions that the court should ask, court hearing the fraud action, should ask whether there was a fraud as the first question. Now, we fully accept that the overarching question is, was there a fraud? But that begs the question of what material needs to be looked at to answer the overarching question of whether or not there was a fraud. And the reason why we were focusing so heavily on the plan, if we were right that there was a plan, it meant much of their evidence was dishonest. And it also gave a motive for the reasons why they would delete text messages, delete emails, and delete WhatsApp messages. And also, would not only demonstrate that their oral evidence as to there being no plan was dishonest, but it would have fed through to all the other questions that Judge Ruston had to ask himself as to whether or not 89.5 had been used for a proper purpose in the end, whether or not the subcommittee was independent or not, and so on and so forth. And it also, the existence or otherwise of a plan, gives a motive for deletion of documents. And that was very important when it comes to Wilton Park. So, that deals with that. My Lord Justice Popplewell asked the question about, well, what happens if it was finally balanced and then new documents come to light? This is the documents 11 to 15, which, when read in conjunction with the original documents, would have produced a different outcome. And we say there's absolutely no policy reason for restricting the scope of the inquiry to the new documents. And one's entitled to ask a rhetorical question. Why should the victim of a fraud only be permitted to get home if the fraud is established by solely looking at the new documents? What's the policy reason to justify such an outcome? If, going back to Lord Justice Popplewell's example, the new material, the documents 11 to 15, I think it was, when viewed in conjunction with documents 1 to 6, make it absolutely plain that there was dishonest evidence given below, and give rise to an overwhelming inference that relevant evidence was concealed or deleted. Why on earth does justice demand that in those circumstances the judgment should not be set aside for fraud, as compared with the situation where the new documents are conclusive? Now,
No, it's not really that, is it? I mean, you could easily plead, but you didn't. You deliberately failed to disclose a memorandum X. When the memorandum X was read with document Y that you did disclose, it was perfectly obvious that document Y meant one thing, but the judge thought it meant another thing because he didn't see the new document. You could have put your case in that way, and that would have been the fraud you were seeking to establish that was practiced on the court.
that's how I did put it. That was the point.
But you can't say it's a fraud because when you balance every document that was before the court on the balance of probabilities, you're going to come to the conclusion there was a plan. You have to have something that is in your hand, as the authorities show, that is, to put it in the vernacular, a smoking gun.
Well, we did. That's the point. The new material that we have...
But you failed.
But only because of the approach adopted by the judge. He only looked at the new material. And I was responding to what the question or the example posed by Lord Justice Popplewell. What my learned friend's argument is, you look only at the new documents as a matter of approach in all cases. Now, we did have...
He doesn't say that. That's not what he said.
Well,
Nobody said you only look at the new documents, that there's some kind of embargo.
I thought
What
that
you
was
have
very
to show
trustworthy.
is that there's a fraud perpetrated on the court. And how you show that is a matter for your pleading. You can do it by reference to old documents, but you've got to have something that wasn't before the court that is critical.
Well, I'm lost. My learned friend made it clear he was not taking a pleading point. My learned friend said he was taking a principled approach to this, and my learned friend supported paragraphs 33 and 34 of the judgment, which dealt with the principle of the approach, the fundamental difference of approach between the two of us. And he was telling the judge, you cannot look at the old documents. And the judge did not look at the old documents. And the way I put the case as to fraud was, yes, we have smoking gun of the new documents, but their weight and effect only becomes clear when viewed in the light of the original documents.
I do find this argument a little bit difficult to sort of fathom out in practice. I mean, the hypothesis is, isn't it, that on the basis of all the old evidence, the point was decided against you, the appellant.
Yes.
Against. So that all the old documents taken together are in favour of the defendant in this case.
Can I just clarify that? Are insufficient to justify a finding of a plan. So they pointed...
Whatever the issue is, all the old material, documents and evidence, were not sufficient to establish it.
I agree with that.
You've got some new evidence, which we know you have to have before you even get into play. Almost by definition, those new documents must be able to make your case.
Well, they filled in the gaps left by the original documents.
But the original documents we know are against you, so in a sense...
I don't accept that they're against me. That's why I'm...
Well, they are taken as a whole because you lost.
They weren't strong enough to make a finding in Mr. Tinkler's failure.
But they're not going... There's a point Kate floated into the argument yesterday, but it's difficult to see how, in a sense, looking at the old documents conceptually will improve the prospect of demonstrating fraud. If the new documents don't.
Well, looking at the old documents to prove the plan, and the plan, once you have the plan, you then conclude that the evidence was false.
Yep.
And when you're looking at motive, there's no principal basis just for looking at the new document.
But in a sense, I'm struggling to understand why just looking at the new documents wouldn't enable you to establish the plan. I mean, if they are, I mean, the whole point about the new documents is they have to be in your favour. I mean, you're not going to come to court and say, we've got some new documents. They just support the judge's conclusion at the first trial. You have to say it's quite clear that looking at the new documents, the judge's finding at the first trial was wrong. There was a plan.
And we did say that.
Right. But I'm not sure why looking at the old documents, as it were, materially advances your case rather than just saying, look at the new ones.
Well,
I mean, in a sense, you don't have to carry all the baggage of the old documents, which by definition didn't prove your case. You just look at the new ones and you
because
say, look at the
looking
new
at
ones.
all the information, looking at the whole pool of documents strengthens the case. It's put it all in the scale. The first round of documents.
But you know, okay, if you've got okay, let's use the scale analogy. Your new documents must be ones which weigh heavily on your side. You know that the old documents were against you and would have.
I'm sorry to keep cavilling at that. The old documents suggested that there was a plan, but there weren't many old documents that suggested there was a plan, and the judge was persuaded that there wasn't a plan. There wasn't any documents which pointed against a plan. It's just there were. It's a bit like island hopping. You've got few bits of evidence in the sea which suggests that there was a plan, but in the end, the judge wasn't satisfied that they were.
It's not really as binary as a plan, anyway. I mean, the whole thing is that what the judge found is that there was, if you like, a plan. It was just a different plan from the one that you were advocating. I mean, I think if you make it so binary, it sort of really disguises the fact that this was a complicated commercial action. And, you know, the judge reached a conclusion about what had happened day by day over the period. And you had to show that that judgment was materially affected by fraud.
Yes.
And you had to plead it carefully, as we've seen from all the cases, and you did, and you failed. Now the question is, did the judge do something wrong? And if so, what? And you say, well, he should have tried the whole issue of whether there was a plan by reference to everything before the court. And what's said against you is, no, that's the job of what happens when you've set aside the judgment. That would happen at the retrial. Once you'd persuaded the court that there was an operative fraud which impeached the judgment, you then go back to a retrial, and the next judge, judge number 3, tries the question of whether there was a plan by reference to all the evidence, old and new.
Well, can we test it this way? Let's say the new documents show conclusively that there was a plan. Then the judgment is set aside on the grounds that it's been obtained. First judgment was obtained by fraud.
That's all it's set aside on. The finding of fact is not. I mean, there may be an incidental finding, but the finding of fact is that the old judgment was affected by material fraud committed by X, Y, or Z. So it's set aside.
Yes.
And then there's another trial.
And my submission is there's no principal difference between looking at the new documents on the one hand and looking at all the documents that go to the question of whether or not there was a plan.
I think I understand the point, certainly whilst that exchange has been going on. I get your point. You're saying, I think, is this right, that the reason that the first judge may not have found that there was a plan was because there just weren't enough weights in the scale to take him, and you just need to add a few more, and that's what the new documents do.
That was exactly
so. If you were just to look at the new documents on their own, they might not also demonstrate that there was a fraud. You need the two together.
They had the same problem as the first lot of documents. Exactly. They tilted the scales to a certain extent. No, exactly how I opened the case, exactly how I ran the case, exactly how I closed the case. And I repeat, what principal objection can there be if the total pool of those documents show that there was a fraud perpetrated on the court? If they do, why should the victim of that fraud be in a different position just because he's unable to establish the fraud but solely by looking at the new documents in isolation.
Can I come back to your balancing of the scales example? Because what the judge in fact said he was doing, at paragraph 221, was determining whether the new documents or evidence provide cogent evidence of dishonest conduct.
Yes.
So he was deciding whether they had any weight, as it were, to be added to the scales on what you say was something that was already there but of insufficient weight.
Yes.
Well, what's wrong with that? If, as he concluded, they don't provide any cogent evidence of dishonest conduct, the new material doesn't.
Can you just remind me what paragraph you're reading from?
221.
Thank you. Well, my answer to that is if he'd looked at the pool of relevant documents on that issue, he would have been satisfied that there was dishonest conduct.
No, but before you put anything into the scale, anything additional, you've got to look at the new material. If the new material is wholly irrelevant, let's say, then you can't just have a second pot based on the old material alone. Would you accept that?
I agree. I accepted that yesterday.
Yes.
So
the exercise does involve
yes,
making an assessment of the evidential weight of the new material. That's part of the exercise.
but he didn't. Yes, but what he didn't.
Of the new material
Yes.
itself.
But what he didn't do, he didn't say, I don't believe that new material is of any prima facie weight at all. The exercise he went through was looking at the new material and then seeing what answers the witnesses gave in respect to the new material and then concluded that it was the new material wasn't of sufficient cogency to satisfy them as a fraud. So no one at any stage said this new material is irrelevant, it is of no weight at all. His conclusion that it was of insufficient weight was only reached by asking himself what evidence each witness gave in respect to the new material.
Yes.
And the criticism is that actually if he'd looked at the new material and the old material, he wouldn't have accepted the witness's answers. That's what it amounts to. Because taken together, the pool of documents provided compelling evidence of dishonesty.
I do have a problem with that, which we explored yesterday, and perhaps we don't need to go over it again, but his assessment of the weight, if you like, of the new documents was done against the background of your cross-examination, which compared, as it were, cross-examined the witnesses by reference to the new and old.
This is the section, this is paragraph 255 again, is it?
Well, it's... No, it's not just 255.
No, I know, I wasn't being rude,
no,
but
but
that's the point.
I was actually, it's 22. I was looking at 221 there, but it may be that it's the same. We had this exchange, but I mean, the idea that he hermetically sealed himself into a box marked new documents is difficult to accept in circumstances where your cross-examination about the new documents inevitably involved the background of the old. That was the whole thrust of your cross-examination.
Well, I think we went over this yesterday. Yeah. With respect, I didn't understand my learned friend to be arguing that reference to cross-examination in 255 or even in 221 means that he was in fact looking at the old material. And if he had been, if the right question was to ask, first of all, was there a plan? Because of all the consequences that flowed from it. And if that was the right question for the judge to consider, he should have considered all relevant documents going to that issue.
Okay, I think that with respect, that is a different question. I was just picking up your point. You're saying that you were trying to say that in essence he only looked at the new documents when assessing their weight for the purposes of whatever the issues were. And
that's what I believe he did, yes.
Yeah, okay. All
right. I mean, I don't think I can improve on my submission about that yesterday. I mean, I took you through it in answer to your question.
Yeah, no, I think we've dealt with it.
All right.
There is another way of looking at this. Yeah. If my learned friend was right to say one should adopt a restrictive view, you should just be looking at the new material. Does the new material have sufficient cogency to satisfy the court there's been a fraud? He then said, when looking at workability, well, if you make a finding of fraud on the new material, then there won't be an issue of stop at the new trial, and therefore at the new trial, the parties being found guilty of fraud at the fraud trial can then reopen the whole issue. This is unreal. That's tantamount to saying that at the fraud trial, the defendant accused of fraud can't point to old material that points in the other direction. And justice must require the person accused of fraud to be able to do so. So if you look at the problem the other way round, this restriction that my learned friend is arguing for is entirely artificial. It would be absurd. It would be bordering on the outrageous if someone accused of fraud, by saying, I come along on behalf of Mr. Tinkler and say, here are these new documents, they're strong prima facie evidence of fraud. It'd be quite outrageous if the other side were not able to say, well, yes, you might think that, but look at the following material that was before the court.
The fraud question is, was there concealment or perjury? Now, there may be a different answer in relation to document. I mean, in relation to documents, it's probably it's a more straightforward thing. The question of fraud in relation to concealment of documents and non-disclosure of documents is looking at the process,
yes,
isn't it?
Yes.
So, in a sense, there's no necessary reason why you would need to look at old documents. You just have to examine why was this document not part of the trial.
Well, let's stick to the plan then. So let's say the new document showed that there was a plan. Is it really to be said that my learned friend would not be able to point to other documents that were before the trial judge to point to the other conclusion?
No, but the point is what you pleaded.
But no one's taken a pleading point.
No, it's not a question of pleading points. It's a question of the case you advanced.
But I advanced. I'm sorry.
Wait a minute.
Apologies.
The case you advanced was that the critical undisclosed documents show that Brady, Soanes and Ferguson all gave false evidence to the court as particularised below in the context of the trying to prove a plan at paragraph 11. And that's what you tried to prove. And once you'd proved they gave false evidence, then there would be a retrial and they could come back and say, well, we may have given false evidence, but there was still no plan because of this, and all these other documents, so we still win. But they've still been proved to have given false evidence, to have been perjurers, and to have failed to disclose critical, undisclosed documents. Those are the wicked things they've done that you sought to prove. That the plan is something to be decided by a judge hearing the case.
But it was the plan that that enabled me to prove the dishonesty and the perjury.
May well be, yeah.
And the concealment. So I had to go there. And yes, I see the way paragraph G in the pleading is put, but I opened it in a much broader way, closed it in a much broader way, with no objection. And I'm not sure it would be fair now to say you were restricted to your pleading when the case was run in a different way without any complaint, either from my learned friend or from the judge. So that's what I say about that. Can I now go on to...
I mean, that's why I put it, if you remember, to Mr. Lieber, that he had accepted and not complained about the way you had been running it.
Yes. Can I go on to Hunter? Hunter's
Yes.
quite important.
Yes.
The 3 points I want to make about Hunter. The observation made by Lord Diplock was limited to a collateral attack and criminal cases. The dictum from Earl Kearns was made in a very
You're going
different...
to have to take it more slowly.
I do apologise. The observation...
Sorry, can you just give me the reference, Hunter, before while you're making these submissions? I'd just like to turn it up.
I'm going to bring you to the...
Yeah, but
in a moment.
I'd like to have it in front of me when you're saying
Oh,
stuff.
okay, so it's 143. But I was going to take you to Flower and Lloyd and Hip Fong first.
Okay.
That's why I was hesitating.
Trouble is, I don't have an instant recall of the passages that you are referring to.
Yeah, of course.
Right.
So point one is the observation was limited to a collateral attack in a civil claim on a criminal trial. The second point is that Earl Curl's dictum was made in a very different context and is not applicable to a case such as this. And thirdly, and in any event, Hunter was implicitly overruled by Tacker.
Overruled?
Yes.
It can only be overruled if the court is told that they are being asked to depart from previous authority. So you'll have to show us that the Supreme Court was asked to depart from House of Lords authority.
The logic of the Supreme Court's approach necessarily means they didn't think, oh, Kearns' observation applies to a case like this.
That's a different point. That's the second point. The third point is the one I'm asking you about.
So can I start with Flower and Lloyd?
Yeah.
And it's page 300 in the judgment of the Master of the Rolls. And there were historically two types of approach.
Sorry, page 300 of
the Flower and Lloyd judgment.
what's it in the authorities bundle? Sorry.
It's tab 4 of the KBW.
Sorry.
Handout.
Yes.
So 5 lines in on page 300, so there's no doubt that under the old practice you could have brought an original bill to impeach a decree for fraud. You could have got relief if fraud in obtaining the decree was proved. There was another totally different class of cases where you discovered subsequent matter which showed that the decree was wrong, although there'd been no fraud in obtaining it. That was called a supplemental bill in the nature of a bill of review, which brought the new matter forward and again enabled the court to do justice and get rid of the original decree. That always required leave. So there were two approaches. In a fraud case, you could do it as of right with an original bill. If you were just relying on fresh evidence, you needed a supplemental bill.
The second is equivalent to an appeal out of time, and the first is a challenge for fraud.
Can we then go to hit fon?
Is that right?
I'd like to, before I answer that, can I just take you to Lord Buckmaster?
Yes.
And hit fon on page 894. We pick it up actually perhaps at the bottom of 893. It is however urged on the appellant's behalf that the learned judge's conclusion was due to misapprehension on his part of a decision in the House of Lords in Brown and Dean. In that case, it was stated in the opinion of Lord Lawburn that when an application is made for a new trial on the ground of discovery of new evidence, must be, at least be such as presumably to be believed, and if believed would be conclusive. But that case had nothing to do with either fraud or with surprise, as was indeed pointed out. It dealt merely with the claim for a new trial based on the ground that further evidence could be obtained that was not obtainable when the trial took place. Fraud or surprise or both are the ground of the application in the present case, and the learned judges were in error in thinking that the authority in itself had any direct and present application to the matter they were considering. In all applications for a new trial, the fundamental ground must be that there's been a miscarriage of justice. If no charge of fraud or surprise is brought forward, it's not sufficient to show that there was further evidence that could have been adduced to support the claim of the losing parties. The applicant must go further and show that the evidence was of such a character that it would, so far as it can be seen, have formed a determining factor in the result. Such considerations do not apply to questions. Sorry, I got tied up. Do not apply to questions of surprise, and still less to questions of fraud. A judgment that's tainted and affected by fraudulent conduct is tainted throughout, and the whole must fail. So there's a distinction drawn between fraud cases, and if the judgment is tainted by fraud, it's set aside, and cases of fresh evidence, where fresh evidence has to be compelling or determining factor in the result. We then go on to Hunter.
What do you say about the the suggestion that the fundamental aspect of it is miscarriage of justice.
Well, I wouldn't put it quite like that. Can we then go on to Hunter in the supplemental and in the original authorities bundles, page 143?
Hunter.
So 143. The context in which Lord Diplock made his observations between C and D is set out in A to B. There remains to be considered the circumstances in which the existence at the commencement of the civil action of fresh evidence obtained since the criminal trial and the probative weight of such evidence justify making an exception to the general rule of public policy that the use of civil actions to initiate collateral attacks on final decisions against the intending plaintiff by criminal courts of competent jurisdiction should be treated as an abuse. Now, pausing there, the fresh evidence relied on in Hunter was fresh evidence in relation to a matter that had already been determined in the voir dire and finally by the jury. So it wasn't fresh evidence giving rise to a different cause of action. It was just better evidence of a matter that had already been determined. And it's in that context that he cites phosphate sewage. And we get an insight into phosphate sewage and Takar if we go to 8.
Yeah, it wasn't just better evidence. It was, sorry, wasn't this the, this was the people who'd been convicted. This was the IRA
the bombers. Yes.
And they were saying, yes, we know we were convicted, but actually they mounted a civil action in which they wanted to introduce new evidence to demonstrate they weren't in fact responsible.
No. It was new evidence showing they'd been beaten up. It was new evidence as to bruising. They ran the voir dire on the basis.
Yeah, okay, all right.
They'd been
Sorry. Yes,
beaten
that's
up
right.
by the police.
Because their defence of the criminal trial was that these confessions were
Exactly.
extorted from us.
Yes. And they lost the voir dire on that basis, and they lost the criminal trial on that basis. And the new evidence was additional evidence as to bruising being found when they got to the prison.
Okay, but to, in a sense, to overturn in a civil proceeding the conviction that
Exactly.
in the criminal proceedings.
So
that's the only thing I was just trying to get straight.
Yes. So there are two important strands. One is using civil action to attack a criminal conviction, and that was the context in which Lord Diplock was saying what he did.
Yes.
Secondly, I just wanted to emphasise before we get to Takar that what Lord Diplock had in mind and what Earl Kearns had in mind was this is better evidence of a point that had already been run and lost, which is entirely different from a case where you discover fraud after the trial. And can we go on?
I don't follow that distinction at all between fresh evidence and better evidence. The fresh evidence in this case could be characterised as what you say is better evidence that there was a plan.
No, but in this case we were saying it's evidence of fraud. And it's a distinction in hip thong.
But to pick my lord's point up, I thought we had this exchange a little while ago where you accepted that in truth, if you use the scales analogy, the new evidence is what tips the scale definitively in your favour, as opposed to what was inadequate evidence which was in front of the first instance judge.
Yes, it goes to that issue. You're quite right. I shouldn't have said no, but the circumstances are different because it's now being relied on in support of a plea for fraud, whereas in Hunter, it was exactly the same point. It was whether or not there'd been...
Whether they'd been beaten up. Yeah.
Yes. So if we can go to 824...
Why is that not the same whether there's been a plan?
Because Hip Fong says, if you've got evidence of fraud, you don't have to show that the new evidence is determinative. It's only when you're seeking to get better evidence of a point already argued that you have to show that the new evidence is likely to be determinative. That's the distinction made in Hip Fong. And when you get to Lord Earl Kearns, he made his observations in a case where there was an original plea of fraud And on the back of that, the plaintiff had sought to prove in a sequestration in Scotland, on the basis of original plea and fraud in the Court of Chancery here. The plaintiff then amended his original plea of fraud to add one additional ground of fraud, and it was held he couldn't. And so, if we go to page, forgive me, I haven't got there, go to 824.
824 of what?
Of Takar. We can pick it up at paragraph 34. Lord Justice Patton referred to the case of phosphate. It had been argued in that case that evidence of fraud other than that presented at the original trial should be allowed to enable a company to claim repayment.
Sorry, you've lost me. I don't know where you are now.
824, paragraph 34. I'm sorry, I didn't.
Paragraph 34 of Tacker.
Yes. So in paragraph 38, Lord Justice Patton referred to phosphate. It had been argued in that case that evidence of fraud other than that presented at the original trial should be allowed to enable a company to claim repayment of a sum which it paid to its bankrupt. The company has subsequently obtained further evidence of the fraud. It sought to advance a new case founded on that evidence. The House of Lords held that the new allegations of fraud were based on facts within the company's knowledge. The plea of res judicata succeeded, therefore. Importantly, Earl Kearns said this: it would be intolerable if a party who had been unsuccessful in litigation could reopen it merely because, since the former litigation, there was another fact going exactly in the same direction with the facts stated before, leading up to the same relief asked for before, but it being in addition to the facts in the previous litigation, it ought now to be allowed to be the foundation of a new litigation. It should be allowed to commence a new litigation merely upon the allegation of this additional fact. The contrast with the present case is immediately obvious. This is not an instance of the claimant seeking to produce evidence of facts going in the same direction as facts previously stated, because Mrs. Tacker had not asserted that Christians had been guilty of fraud, merely that she had no recollection of having signed the profit share agreement. The relief that she now seeks is quite different from that which she had earlier claimed. Previously, she sought to avoid the effect of the agreement because of undue influence and unconscionability on the part of the Christians. Now she claims that the agreement on which they rely was in its written form forgery. Now, it's true that Earl Kearns also said that the only way in which new evidence could possibly be admitted would be if the litigant were prepared to say, I will show you this is a fact which entirely changes the aspect of the case, and I will show you further that it was not and could not by reasonable diligence have been ascertained by me earlier. But the essential context of this observation is set by the earlier passage quoted above. It's where precisely the same relief as had previously been claimed is sought again. Now, we're not seeking precisely the same relief as been sought before. We're seeking relief in a different course of action. And we say that in those circumstances, what Lord Diplock was saying, in the very limited circumstances in which he was making that observation, has absolutely no application here. Nor does Earl Kearns's observation, because that was a case where they were seeking to just put in a bit more evidence in respect to a matter where they were seeking exactly the same relief as they had sought before. And we're not seeking the same relief. Yes, there was an overlap of issues, but as Lord Briggs said in that passage I took you to yesterday, it goes with the territory of this type of claim, that the court, second court, will have to go over old ground. So Hunter is not binding on you. My learned friend, then moving on to materiality, my learned friend said that we need to succeed on ground 2 and or ground 3 as well as ground 1. We fundamentally disagree with that.
Is it right that, that what you've just been submitting to us is in fact encapsulated in paragraph 39 of what Lord Kerr said?
Yes. Thank you. Yes, so Lord Kerr clearly doesn't think that observation from Earl Kearns applies. And that's not just limited to the due diligence requirement. So on materiality, the problem with the judge's approach to materiality is that his analysis of materiality was based on what we say is a flawed approach to determining factual issues. The judge, as you've seen, asked himself what the new evidence showed, contrary to our position where you say he should have looked at all the relevant evidence. And his findings as to materiality are by reference to his flawed factual finding exercise. And in every case, or in virtually every case, as I read the judgment, he actually asks himself the wrong question when it comes to materiality. And if I'm right about that, it means ground one is a standalone ground that doesn't rely on me to make good ground two. So,
what is the question he asks himself that's wrong on materiality?
Can I give you a couple of examples? You have it's fact specific. So,
you said in almost every case, but you're going to just give us.
Well, I'm just conscious of time. I'll give you as many examples as time allows.
Right.
So, if we look at issue 3, the question in issue 3 is posed at 322. Did Mr. Brady and Mr. Folkeson intend to use Article 89.5 to remove? We say he answered that question by adopting the wrong approach. And he assesses a materiality in 332 just by looking at the First Amendment to Mr. Laycock's employment contract. But the question he should ask himself, if I was wrong in finding that they didn't intend to, if I had found that they intended to use Article 89.5, would that have been material? And of course, if we posed the question in that way, the answer would obviously be yes. Then we go on to issue 4 at paragraph 333, where he refers back to his analysis of issue 2, but I'm setting the scene. He says, not satisfied that Mr. Brady deliberately deleted his WhatsApp messages or deliberately withheld that information. And he deals with deliberate deletion materiality at paragraph 321 on page 228.
Sorry, give me that again.
He deals with materiality at paragraph 321 on page 228.
228?
Page 228.
So I thought we were on issue 4.
Yes, but sorry, issue 4, if you go back to 333, he refers back for the reasons which I set out in my answer to issue 2, which is why he directs us.
I'm with you. Sorry, yeah, I'm being slow. Right, 228.
228, 321.
Yes.
Now the question of materiality should be, if I'd found that there had been deliberate deletion of WhatsApp messages or Telegram messages, would I have considered that material? He never addresses that.
But I don't understand this to be a ground of appeal.
It's not a ground of appeal. What I'm saying is, but the ground of appeal is ground 1. We say that as a result of ground 1, he made findings of fact that he shouldn't have made, and they necessarily informed his analysis of materiality.
Well, where's that in your skeleton?
I'll ask behind me.
I'm just looking at it.
Well, is it more accurate to say that it's not that his answers informed his approach on materiality, he just didn't feel the need to address materiality because by definition he'd found that there was no deliberate concealment?
Yes, he didn't address materiality
On this particular issue,
on the
if we're wrong
findings.
on the,
Yes,
right. But if he's wrong on ground one,
then this doesn't arise.
right. On,
So it
on
doesn't only.
this, well, it's just that he hasn't answered the alternative on this particular example.
Yes, I'm not aware that, subject possibly to issue one, which I'll come to, but I'm not aware he's done it, other than Wilton Park, where he said he would be material. The loan agreement, yes, it would be material. If we can look at issue 6, and we can go to page 24, sorry, issue 4 first of all, page 247. No, this is issue 6. This is Mr. Laycock stepping down, and at 362, he assesses materiality.
Hang on, let's go into issue 7.
I'm sorry.
So issue 6, he does do it right, doesn't he?
No, if you look at 362,
Well, no, that's a different. You've just moved on to a different issue.
360, sorry, subparagraph 2. Did I miss?
Sorry.
My mistake. 360 subparagraph 2. The question was whether or not Mr. Laycock was bought off so that the board could then use 89.5 immediately after Mr. Tinkler was re-elected. And the judge at 360 subparagraph 2 doesn't consider the question of materiality by reference to the case that we were running. He considers the question of materiality by reference only to the findings he's made. And if we go on to issue 7, paragraph 361, the question at paragraph 361 on page 248, was there a deliberate deletion? And the materiality is dealt with at paragraph 370. Which is on page 255. He doesn't assess the question of materiality by reference to if I'd found there had been deliberate deletion. And if we go on to issue 9, paragraph 389, we've dealt with, that's the Wilton part where it said what was material. And then issue 9, which starts at the bottom 265, was a deliberate failure to disclose. And at paragraph 407, he doesn't consider the question of materiality by reference to the failure to, if I had satisfied myself that it was a failure to disclose, I would have considered it material. So the findings he makes on materiality in relation to findings of fact that is adopted by using the wrong approach are no bar to Mr. Tinkler's success on this appeal. So that's all I was going to say about that. And very finally and shortly, Cochran and Bailey. We say it's wrongly decided. Highland makes it absolutely clear you don't look at what the outcome would have been. You ask yourself the question whether or not the new material would have, the fraud would have had a material impact on the approach adopted by the judge. And what Lord Justice Aitken says in Highland question of materiality is to be assessed by reference to the impact on the evidence supporting the original decision, not by reference to its impact on what decision might be made if the claim were to be retried on honest evidence. If my learned friend was right, you basically ignore the fact that they had lied, you ignore the fact they'd purged themselves, and you ask yourself whether or not you assess materiality by reference to what the true position was. But that's not the right approach. You must assess materiality by reference to the fraud and its impact on the judge's approach to the case. And if you ask yourself that question, the answer is obvious. And the criticism we make in our ground 3 is that I lost. Sorry. I just lost my skeleton. What the judge does, he just doesn't limit his analysis to considering what the impact would have been if honest evidence had been given, but he looks at the outcome. And he asks himself, well, what would Judge Russian's conclusions have been affected if the witness had provided the information which was alleged to be concealed? And I gave you a number of examples yesterday. Can we just go back to page 288 of the judgment? Paragraph 437. Even if I'd found that Mr. Ferguson lied, I wouldn't find this new evidence material. It's not relevant to consider how the judge's findings would have been affected if he'd known that Mr. Ferguson was not a straightforward or frank witness. That must be wrong. If it had been revealed during the course of the trial that there had been a deliberate concealment of documents or deliberate destruction of documents, then necessarily that's the relevant information that impacts on the judge's assessment. You don't just say, well, now I'm now going to see whether looking at all these new documents, the outcome would have been any different. If we go back to page 286, that is 286, sorry. Go on to 288, same point is made. Sorry, if I already dealt with 288, Mr. Ferguson, it's 286, he makes the same point in paragraph 432 in respect to Mr. Soames. And if we go back to page 208, the judge at 2871, third line, says it's difficult to see how the new evidence would have had a decisive impact on the findings. That's not the right approach. You have to consider the impact of the new evidence on the approach, on the judge's evaluation of the evidence's reasoning, not would he have decided it differently. Same with subparagraph 2. And 3, even if new evidence had shown that Mr. Brady was planning to remove or neutralise, I'm not satisfied such finding would have made a material difference. And he goes over the page, I accept the judge might have gone on to find that. Well, that's the wrong approach. And at subparagraph 6, if the new evidence had shown it's also possible the judge might have accepted Mr. Tinkler's case. But again, I doubt this. The authorities make it absolutely plain you're not meant to be looking at how the outcome would have been different. If tried on honest evidence. Again, with subparagraph 7. If the new evidence had shown Mr. Brady was planning, it's possible that the judge wouldn't have found, but I doubt this too. Again, he's looking at the findings. Again, subparagraph 8. So, my lords, that's what we say about Tinkler and Bailey. Unless I can help you any further, they are my submissions.
Well, thank you very much, Mr. Wardell. Thank you, both of you, and to your juniors and your solicitors. It's been an interesting couple of days. It perhaps won't surprise you that we'll take time to consider judgments, and when we hand them down, we'll hand them down in the usual way, and you are to use them only for the purposes of agreeing any directions and costs, but not for any other purpose. And please send us typographical, but not other kinds of corrections. Thank you both.